My name is Melissa Pachola. I am the Director of Pro Bono and Community Partnerships at Legal Aid Chicago, and I do want to start with gratitude. First of all, I woke up today. I'm grateful for that. Second of all, I'm here with you, and I'm extremely grateful for that. Third of all, I have been given the privilege of devoting my career to legal services for the low income and otherwise vulnerably held, okay? So, some people may not be familiar with the concept of legal aid, right? What does that mean? And typically, I always have to tell people that free and lawyer don't typically go together, do they? Right? We are free lawyers, right? We provide free legal assistance to those who qualify for our services. We do a wide variety of things, as I just said, and I'm just gonna leave this up here without talking extensively about any of them. But what we really want to make sure that we emphasize is that if it's a legal issue, we typically can help with it as long as it's not criminal defense or something else that we don't do, okay? But let's talk about why we're here today. Let's talk about clearing records in Cook County, which is obviously one of the services that we do provide. So I always like to start with this concept of what is a criminal record. And both Reverend Cavaway and Carmichael reference this idea that sometimes you have a criminal record and you don't always know it. The reality is that a criminal record is created pretty much anytime you interact with the police or are arrested in any way. And generally, we divide things into juvenile records and adult records. Now, I don't think I have to spend a lot of time emphasizing that this arbitrary distinction based on age is truly arbitrary, and that there are certainly situations where you may have been arrested at the age of 16 and charged as an adult. And we can talk for hours about why that might be. The point is, when you come and present to us and say, I have a certain type of record, we have to figure out which type of record it is. Right? Because it's not often just based on the age that you were when you were arrested. It's what age the system thought you were, and any sort of decisions made about how to prosecute. We can help with expungement, including juvenile records, sealing of adult records, and professional license waivers and certificates. So that's sort of the scope of what we do. We deal with records in Cook County, and so Cook County includes the suburbs, right? But it doesn't include things that happen downstate, downstate or otherwise out of state, okay? It also doesn't include federal records, right? So that's a separate system. Unfortunately, there is no expungement process for federal records. The only option to get a federal record off of your background is actually to seek a presidential pardon. And I don't know about you, but I don't know Joe like that, right? I don't have him on speed dial. Maybe Reverend Callaway does. She's pretty famous. I don't. So just to say that this is what we can do with records that occurred in Cook County. What we do as free lawyers is we take a thorough look at someone's record. So many times people say, well, I just want to ask a question. Can you just tell me if I'm eligible? And I will often say, nope. I need to look at the entirety of your record, and I need to do a deep dive in comparing what is on your rap sheet, for example, with what you're telling me, with what is in the court file, to truly get to the answer of eligibility. So I don't ever want to discourage people from using the resources that are available to them, but we feel strongly that the lawyers that we have trained to do criminal records analysis are really good at this and get it right most of the time. When we take on a case, we are that person's attorney throughout the entire process. So we do not prepare paperwork for people and then say, okay, good luck to you, please file this in court and let us know what happens, or don't let us know what happens. When we take on a case, we act as their attorney throughout every step of the process. We feel this is important for a number of reasons. One of them is that the court process can be complicated and often unfair and often confusing. The second is that what I often like to say is that clients are often not single issue clients. So you might come to me and say, I'm really interested in getting this off my background, And then 2 months later, you would say, hey, I applied for a job and something bad happened, right? Or I'm being evicted, or I'm having a situation with my family. And so we want to make sure that we're there with you to help you with those other issues that may pop up, to see if we might be able to remove those barriers that are on your path. And then, of course, as I said, we do the internal referrals for other legal issues we might handle. Okay, we're going to talk about adult cases first, and we're going to talk about the difference between expungement and sealing generally. Okay, this is what we all need to understand as a basic thing. Non-convictions, those are eligible to be expunged. Convictions are eligible to be sealed. Okay? So when we're thinking about adult records, this is the big difference. You cannot expunge an adult conviction, pretty much ever. I will not submit a petition to the court that asks the judge to expunge an adult conviction, because that is not eligible. It's not that the judge might decide he likes you, he or she, let's call her she, because let's give women power. She likes you and decides to sign that order. It is not eligible, and therefore an adult conviction cannot be expunged. It can be sealed. So let's talk about what that means. When something is expunged, this is why we put an eraser on this slide, it's the total erasure of the record. It is typically the entire destruction of the record. It cannot be accessed anymore. Technically, if you really wanted to unexpunge something, you could ask our friend, Madam Clerk, to try to find that record. But I do not want to make that request. I certainly do not want to be in court asking a judge to unexpunge something. I don't like getting laughed at in court. I like getting laughed at when I tell jokes. I don't like getting laughed at in court. So generally, it's like it's totally gone. In fact, when we receive expungement orders in adult records for suburban districts, a lot of times they will send the entire record back to us. So that fingerprint card, the original police report, that mugshot, it actually gets sent to us and then we destroy it. Ask me why they need to mail it to me so I can destroy it. I don't know, but I'll do it because I know it's done, okay? There are some exceptions as to who can see expunged records. So we are very careful with people who have anything less than a citizenship status in expunging their records, because immigration, which is USCIS, as we often call it, can still see those records and they want to know about them. So when someone comes to us and they say, I'm a legal permanent resident, or I'm here on a visa, or I have DACA, we're very cautious about how to advise them before we proceed. The military can still see expunged records. The FBI can see it if the record was sent to them, and there's sort of this category of offenses that are sent to the FBI by the police department. And then law enforcement in very rare specific cases, okay? So there's some kind of first-time offenders, their records are still sometimes sent to law enforcement even if they're expunged. Sealing, on the other hand, and again, it's like putting a lock on it, right? And only certain people have the key to that lock, only certain people are entitled to unlock that record. Again, sealing is the remedy that's available for adult convictions. The case information is removed from public view. So if you've had your record sealed and you come to me and say, I want to know what happened here, I can't access it. I cannot do it. I am a member of the public, even as a lawyer. Law enforcement still sees sealed records. No one else can see sealed misdemeanor convictions, but if you are fingerprinted, felony convictions will still show up on that background check. Okay? So the difference, of course, is that if someone runs a name-based background check as opposed to a fingerprint-based background check, this will not appear. But if someone's applying for a job, for example, that involves any type of childcare, right? If children are in the building, typically they run their fingerprints, and felony convictions will still appear. Schools, right? Hospitals, which is sort of fun. Banks, Any type of government job. So you want to apply for the park district, they'll do your fingerprints, okay? So this list of who can see sealed records is important for us to note for a number of reasons, not to be discouraging, but to encourage you to say the following. Juvenile records are sealed already, okay? And so people often think, I don't need to do anything with my juvenile record because it's already sealed. But look at this list of people who can still see sealed records. The good news is that most juvenile records are then eligible to be expunged. Again, when I am doing these presentations, a lot of times people will ask me, well, I have a burglary, is that eligible? And typically it's not the type of crime, it is the sentence, right? Is it a conviction or is it a non-conviction for me to determine the eligibility in terms of expungement or sealing? So let's talk about what would be a conviction. Anything where there was no petition filed, where it was dismissed, is a non-conviction. And in criminal court, they use these funny terms for non-convictions. They like to say nollied, they like to say SOL'd. Very rarely do they say dismissed. But essentially, that's what that means, if you were found not guilty or a finding of no probable cause. And on this side of the screen, we've got a couple of sentences that if you complete them satisfactorily, according to the court, you can actually expunge them, okay? So many of us have heard of second chance probation or 710-1410, which is typically for drug offenses, though not always. And then supervision, as long as you do, and again, all of this depends on you doing what is being asked of you and the court determining, yes, you have done everything you want, and then they want you to do, and then there is a notation that you have done this satisfactorily. What is not on here is regular probation. So again, convictions are typically supervisions that are not completed satisfactorily. Regular probation. So if it's not a special or a qualified probation, it's considered to be a conviction. Conditional discharge, boot camp, fines, any prison or jail time, including this fun little scenario where you get arrested, they hold you, you appear in front of the judge, and the judge says, go home. But what actually happened is you were sentenced to time considered served, right? Which is why I always want to research someone's record carefully and thoroughly before I advise on eligibility. There are some small category of offenses that are never eligible for relief. So a conviction for domestic battery, a conviction for a violation of an order of protection, convictions that fall under the Humane Care for Animal Act, so animal cruelty, dog fighting, those things, if you're convicted of them, have to stay on your record. Sex crimes, so solicitation for sex offenses, criminal sexual assault, all of those categories, if there are convictions, they're not eligible. And then a conviction of DUI or reckless driving, even if you just got supervision. Again, it is complicated because so much of what happens in criminal court is you might be charged with one of these and then you pled down, right? So much of what happens in criminal court is that you don't remember what happened, which is totally reasonable. And so the other thing is that sometimes these pop up, but the important thing to know is that just because you have one of these convictions does not mean that anything else on your record is ineligible. Okay, so let's say I have one conviction for domestic battery, but I have 4 arrests for other things that happen, right? Disorderly conduct, something like that. I can still expunge the rest of my record if they're non-convictions, and I can seal everything else that's eligible, right? So it used to be that you had to do this complicated analysis of, oh, if you have one thing, nothing on this list makes you ineligible with regard to the rest of your record. Now, if you come to me and say, I have a single domestic battery conviction, can I do anything about it? I'm gonna say, no, right? Because that's all you've got. But, you know what I would actually say? Get your rap sheet, let me look at it, let's take a look, right? Because I'm gonna wanna see, and I'm gonna wanna look up that case to figure out what happened. Okay, juvenile records. So this is the thing to remember. Juvenile who are charged as juveniles cannot be convicted of anything. They can be adjudicated guilty, but our legal system and our judicial system has determined that juveniles who are charged as juveniles are not considered to be convicted. They are adjudicated. And therefore, we can expunge those records, right? They're already sealed. So if it's a juvenile record, unless it falls into the very, very narrow exception here, you can seek to expunge it. So the only exceptions are findings of guilt for first-degree murder and felony sex offenses where you're currently required to be on the sex offender registry, on the juvenile sex offender registry. So I will say also that typically the second one, the felony sex offenses where you're required to register, that's typically a time-limited period that you are required to register. It's typically 10 years, and there is a process to get off that registry if you're on it, right? So if you find a way to get yourself off of the sex offense registry, then you can actually seek to expunge that particular conviction. I'm sorry, adjudication. Okay, so juvenile records, almost everything is eligible. And remember that even though they're sealed, a lot of people can still see them. So if we see a juvenile record, we file for expungement. There are a couple of wait periods with regard to adult records that I just want to pause and talk about. So there is no wait period if the case was truly dismissed. There's a small wait period, small to me, probably not small if you're experiencing it, so 4 to 6 months if it was stricken off with leave to reinstate or other type of special dismissal. If you complete supervision satisfactorily, you have to wait 2 years to expunge that record. If you have a special sentence as a qualified probation, it is 5 years to expunge that record. But this is the one that trips people up the most. It is a 3-year wait period to seal a conviction from the date of your release from the last sentence. Okay, so 3 years from the date of release or completion of that sentence, let me be very careful about that because it includes parole, to seal anything on your record. So this one applies to all of the things on your record. Sometimes it's helpful to use an example, and why don't we? Because it's hot and we're all gonna fall asleep if we don't start interacting, right? So let's say that I have a friend, his name is Emilio Expungement. We hang out all of the time, me and Emilio. He's a fictional client that I made up. Let's say that Emilio, in 1990, got arrested for robbery. He serves 2 years of his probation, regular probation. He completes it satisfactorily and he moves on with his life. He then, in 2022, gets picked up again. He gets charged and convicted with disorderly conduct. He's sentenced to 1 year of probation, which he completed in May of 2023. No parole, so his sentence is complete on May of 2023. When would Emilio be eligible to seal his record? All right, we've got it. May of 2026, so he's in a 3-year wait period. What about that 1990 conviction? Same, right? Everything is now thrown into a wait period because of that most recent sentence. I want to emphasize, because we were talking, and I know some of you offer these programs, if you earn a certificate while you are completing your sentence, so that includes on parole or while you're in prison, a vocational or educational certificate. So if you get your GED, if you get a forklift training certificate, if you do something else while you're serving your sentence and you complete that course, then you can seek to seal as soon as your sentence is over. So let's say that Emilio, while he was serving his most recent probation, in November of 2022, I'm just gonna plug you, he went to this program and got a forklift certificate, forklift trainer certificate. When then could he seek to seal his conviction, right? Remember, he completed his probation of May of 2023. That's right. Exactly, May of 2023. So he's waived the wait period. So these are really valuable courses to know about and enroll in. All of them are. If you are serving your sentence, and again, that includes parole, but it has to be completed while you are still serving your sentence. And this gets tricky for people. Okay. Let's talk about the record process with Legal Aid Chicago, at least for starting the process if you have an adult record or you think you do. You have to get your rap sheet. For an adult record, you have to be fingerprinted. The easiest way to do this is to go to 35th in Michigan, 3510 South Michigan, and ask to be fingerprinted by the Chicago Police Department. It's $16, and they will send you your Chicago Police Department report as well as your Illinois statewide police report. Sometimes we can see juvenile records as that, sometimes we cannot, but don't worry, we'll find them another way. You can then send that to us. Remember, you have to go to get your police department rap sheet, and if you don't have any Chicago arrests, you can still contact ISP. Now, I still recommend, because we're standing here in Chicago, still go to 35th in Michigan. For juvenile records, we can obtain your rap sheet for you. Okay, so if it's just a juvenile record, we can obtain your rap sheet for you, but not if it's an adult record. And if you don't know which, get your rap sheet and we'll figure it out. We then have to register you in our system, so we have to do client intake. We gotta talk to you, we gotta ask you a bunch of demographic questions. We do not have income limits for the purposes of expungement and sealing. So if you're seeking criminal records relief with us, we do not have income limits. But we are required to ask you about your income and your demographic information. We then do our legal research. As I said, we thoroughly review your record, we're cross-referencing, we're FOIAing police departments often, we're pulling the entire case file, we're looking at the entirety of that record, we're finding the juvenile record that you long forgot about, and we're trying to come up with your eligibility. We then complete your paperwork, as I said. We'll then put what we find in our eligibility, we'll complete your paperwork, we'll talk to you about what's on your record and the next steps. You will then sign your petition as a client. There is a requirement that if you have a drug-related felony conviction, you have to submit a clean drug test. The drug test has to be within 30 days of filing, so what we typically tell people is go and get the drug test for this purpose. We do have funds to pay for drug tests if this is a barrier for people. But you have to submit a clean drug test to be able to seal a felony conviction. And we will not file without the drug test. I am not a gambler. I don't gamble about anything. I certainly don't gamble about whether someone's gonna get me a drug test. I wait for the drug test and then I file the petition. Again, it's required. It has to be at least 66 panel. And then technically the presence of THC or marijuana, positive results should not prevent us from filing. However, it's important to note that the judge has total discretion in these adult cases, and the judge just may not like it and find another reason to deny. Okay, so we file, and then we will file your paperwork once it's signed and we get that drug test if we need one, and we always tell you if we need one. And we ensure that everything is complete, and then we file it in court. We then wait to hear back from the court. If we need to attend a hearing to represent you, we will absolutely do that. And we will obtain the final orders in your case, and we will provide you those orders. Again, this sort of three-step process is how we break up our process. We do records research, we complete the petitions, and then we file, wait, and represent if necessary. I should say that in most situations now, a court date will be required. Still, most court dates are occurring via Zoom, so that is helpful. It allows us to live our lives, but also have to go to court. But we will make sure that you know about your court date, and we will tell you what you need to know, if you need to come, et cetera, et cetera. Okay. I'm gonna pause here so everyone can absorb the bad news. It's going a little bit faster now. That's the good news. So most of us live in Chicago. Most of us, if we've gotten arrested, it's been in Chicago, right? Because of that, there is a significant backlog of petitions in Chicago. There's a lot of people asking for the same type of relief. So the petitions take a while to be processed. So recently the clerk has started a process and the court has started a process where you get a first court date as soon as you file, 75 days after that filing. If there is a second hearing though, a second hearing required because there's an objection, we have to then get a second court date, and that second court date is often 6 months later. And then we have to assume that we get the order and everything goes well and we can move forward, which is why we sort of generalize and say the process is it's about a year. Now, this is frustrating. That's why I said it was bad news, right? It's frustrating, and we do everything we can to see if we can expedite this, but the reality is that we can't jump the line, right? The court can only move as fast as it can move, and the judges are only willing to hear a certain number of cases every day. In the suburban district, it's actually a little bit faster, so if you're fortunate/unfortunate enough to get arrested outside of the city line, it can move a little bit faster, but it depends on the district and how they process things, because every district is different. In juvenile court, we typically say the entire process takes about 3 months. The important thing to know about juvenile court is that all of these petitions are heard in one courthouse, in one courtroom, typically in front of one judge. So what that means is if that judge is unavailable, it often means we don't get a court date and we can't have those petitions heard, right? So that's why we generally say it's about 3 months. It can go faster. It typically does not. Talking about the effects of expungement and sealing, and we get this question a lot. So remember when I said that law enforcement can still see felony convictions? They can still see all convictions if they're sealed? That means the Illinois State Police, which processes these FOID cards, can still see them. And the law requires that if there's a felony conviction, that they actually deny the FOID card. So we typically recommend people, if they're denied, seek to seal, right? See how that process goes, and then apply again with the sort of proof that you have about the sealing to see if that might sway things. And then if you are denied, appeal. There is an appeal process that one can utilize with the Illinois State Police to sort of say, hey, look, this is all of the reasons I should get this card, even though I may have a felony conviction that's preventing me from doing that. This is not my area of expertise. And we do not assist directly with applying for a FOID card or appealing the denial. Just a note about housing is that there is a Cook County, what's called the Just Housing Amendment, which provides protections for those who are just as involved in applying for housing in Cook County. It basically says that the landlord is not allowed to sort of say, you have a conviction, you can't rent here. They have to explain to you how the conviction is making it so that you can't live there. If you believe that you've been illegally discriminated against, we do take those fair housing cases with regard to the Just Housing Amendment, so you should call us. Employers can ask about convictions, not arrests. And if your entire record has been expunged, you can say no to the question, have you ever been convicted of a crime? Because remember, expungement is like it's never happened. But if they're authorized to do a fingerprint-based background check, then they will see those convictions and you should probably disclose it. Juvenile records are a little bit different because there are penalties for actually seeing a sealed record, and there are different implications as to whether or not someone can consider a juvenile records. Certain types of employers can still consider them though. I also wanted to say that even if you have a criminal record, the employer is not allowed to just say, you have a criminal record, we won't give you this job. They're required to explain to you why you cannot get that job. And unless they're prohibited by statute, which again is the case for some government employers still, unfortunately, they have to do what's known as an interactive assessment, okay? And if you didn't love lawyers, you'll love them after this phrase. They have to do an interactive assessment of whether there's a substantial relationship between the conviction and the job. Now, I don't know what that means, to be honest with you, but I know that a lot of employers aren't doing it. That's what I know. And so if you're in a situation where you've been denied a job because of a background check and the employer just says, we don't take people with backgrounds, right? We see more and more job postings that say background friendly. We used to see no backgrounds, right? So if you're applying for a job and you're denied because of that, I do encourage you to contact us because a lot of employers are still not doing this right. And it is part of our goals to make sure that we can educate those employers. It's an interactive assessment of whether there's a substantial relationship between the conviction and the job. And again, the statute does not lay out what that means, but they are required to explain it to you, right? They're not allowed to just say you have a conviction. Okay, so summary, wrapping up. Most convictions can be sealed. Most non-convictions, including those juvenile adjudications, can be expunged. This is complicated, right? What I've said is a summary of the law. It did not include all of the nuances of the law, but we are happy to help you. You can call us, you can email us, and then we also have a help desk, which I brought some flyers for, in the juvenile courthouse, where you can walk in and we will do an intake with you. And if you have a juvenile record, pull your rap sheet. If you don't have a juvenile record, but you have an adult record, we will explain to you how to get your adult rap sheet again. Or you can just go get your rap sheet and email us, okay? Again, hey, there's my walk-in services for juvenile expungement. Here it is again. So it's 1100 South Hamilton. It's next to the clerk's office on the first floor. We accept walk-ins. We are there Monday, Tuesday, Wednesday, and Thursday from 9 a.m. to 4 p.m. Here's just one thing to note, is that the judge has required us in juvenile court for us to be in person. So sometimes when you walk up to the help desk, you will see like, be right back, we're in court, because we're in court. But we do our best to keep the desk fully staffed as much as we can, unless we're actually in court at that moment. Okay, who has questions?